You are a regular listener to Talk City. On a Monday, I'm sure you will know that the legal desk, it happens from around 11:30. Colvin Blaize is an attorney at law. He is here to speak about property tax. And we say good morning. Thank you for being here.
Good morning, Dike. How are you?
I'm all right, thank you.
Great.
Wondering about the two pieces of legislation that are involved in what is happening here with the property tax.
Yeah. Well, there are two pieces of legislation. One is the Valuation of Land Act, 69 as amended by the Valuation Amendment Act of 2009. And the other one is the Property Tax Act 2009. Those are the two pieces of legislation that we will have to refer to with respect to the whole rollout of this whole property tax system. Now, what is being dealt with right now really and truly will be under the Valuation of Land Act, where persons have been asked to send in their Schedule 2 forms, providing the Valuation Division with information for which they could then probably do an assessment for the purpose of determining what your property tax should be. So that is what is taking place here now. Under the Valuation Act, at least the Act itself makes provisions for these forms to be put in by the 1st of April, I believe, 2010. All right, that's how the Act is structured right now. I mean, a notice was issued that the form should be put in by the 22nd of March, 2015. There may be some issues that may or may not arise with respect to how that is rolled out or not. After that, if you have not put in your property tax, the form, sorry, then the Act provides that the commissioner, which Commissioner of Valuation, will then serve a notice on you. Once you have served that notice by post and you fail to respond, then you open yourself out to prosecution for an offense which is punishable $500. So that is how the Act itself is structured. I'm just here to probably, as much as possible, give this is what the information is as to what that is how it rolls out, whether it may cause certain issues, definitely from a legal standpoint. I'm not too sure I want to get involved in that, but at least I would want to say this is what it is.
But just before we get closer into that, speaking about the notice that is mailed to you, is there a duration, a time frame that you're supposed to respond to that notice? And I ask whether or not it is from the time of sending or from the time of receiving?
No, from the time of receiving. The Act will set out by post. It will give a particular timeline within which it will accept that you should have gotten that. If there's no response, then the commissioner can then proceed with respect to the issue of prosecuting you for an offense punishable $500. And that is how it rolls out. Again, like I said, because the Act itself makes reference to the 2010, and there's not necessarily been an amendment to that Act. There's just merely being a notice given out that the date for putting it in is the 22nd of March 2017. Like I said, issues may or may not arise with respect to whether that's effective to be able to amend that particular part of the section, because the Valuation Act goes on to say if something is not done by that particular date in 2010, then the only other way that you can then bring it to the attention of the constituents is by virtue of that notice that you need to be able to mail out. And then if you fail, then you open yourself up to prosecution, for which the penalty is $500. And that is how it's rolled out in the Act itself.
What are some of the specific issues surrounding assessment? Well,
those are more valuation issues, I would think. The critical thing is the assessment or the valuation, as we put it, is something to be done by the Commissioner of Valuation. When you fill out your form and you send that in, that information is used by the Valuation Division for the purpose of then coming up with a picture as to what the valuation or the rental values in that particular area is. So it's not conclusive. So it's not as though if I send in and I say, what I charge in rent is $2,500, and then you subsequently get a valuation saying that, you know what, the rental values in this area is supposed to be $3,000. It's not, but I send in something saying $2,225. This is just information that you send into the Valuation Division so that they can get a better picture of what the rental values in the particular area is. And as you would appreciate, valuation is something that is dynamic. So it's not something like 5 years ago it was one particular value. It doesn't necessarily mean have to be that same value now. As a matter of fact, most valuations, if you go into the bank or anything, they say it's valid for 6 months. After that, you need to get another valuation. And that is how dynamic the entire flow of the situation is. The Act itself provides that you do an assessment every 5 years. So they more or less fix it for 5 years. But doesn't mean that in between, that there's not a dynamic that will take place. As a matter of fact, the Act provides that if in between those situations you have increase in the value of the property by virtue of enhancing the property itself, or if you have land when you put on a building, then you may be entitled, based on your valuation, to be able to pay more of your land taxes. And similarly, if there's a reduction, you're entitled to that as well. But it's something that you need to be able to advise the valuation division so they could do the relevant assessment with respect to the value of the property. But with respect to the nationwide assessment, normally the Act requires that you do that every 5 years, as the case may be, with respect to be able to determining that entire flow. Again, it's not static.
If an assessment has been done, you do not agree with it, do you address that imbalance from the side of valuations or assessment, or does there need to be legal recourse?
Well, there's a procedure. And quite frankly, there's a procedure that is set up in the Valuation Act. There's a procedure set out in the Property Tax Act.
Which one do we
And
follow?
they're not, well, we'll have to determine that one because they're not exactly the same. All right, so if you're looking at the Valuation Act, you have 30 days within, if you disagree, you have 30 days within which to indicate to the commissioner that you disagree. If he writes back, he'll write back telling you, yes, it remain the same, it increases or it decreases. If you disagree with that, then you have an appeal with respect to the Tax Appeal Board. And they themselves also would give a response with respect to agree, disagree, remain the same. And again, if you disagree with the Tax Appeal Board, then you have a right of appeal to the Court of Appeal only on a point of law. Right? So that is the procedure. The procedure in the Property Tax Act to a certain extent follows a similar type hierarchy. However, the timelines are different, and totally different with respect to on the Valuation Act as opposed to the Property Tax Act. So I suppose it's something that may need to be resolved one way or the next as we go along. Again, like I said, it's a new piece of legislation that's coming out. They may have certain teething problems. And definitely there will be certain issues to be resolved as we go along.
You spoke of timelines. I want to ask, are there any, and if so, what challenges can be posed by this May 22 deadline or timeline?
Challenges in what sense?
In terms of, are there things that would have been, what should have been put out as notices before? Are there things that we are supposed to, as individuals in society, to be doing by that time?
Well, again, it depends on your interpretation of the Act. The Evaluation of Land Act specifically makes reference to 1st of April 2010 as the date by which you should submit that form. And thereafter, if not submitted, then you have the issue of the notice. If we accept that the issuance of the adjustment by the ministry, that you have until 22nd of March of May of this year to file those form, if we accept that that amends that particular provision, then once that day passes, the next step would be for the commissioner to issue a notice to you. So there's no automatic fine, let's say, by virtue of not necessarily conforming with this particular aspect of the request of sending the form. If then a notice is served and then there's non-compliance with that notice, that then causes the commissioner to be then say, okay, the next step would be for me to prosecute you for this particular offense, for which the fine is $500. So that is the particular sequence in which it will go, it will flow.
Are there any other pieces or any other elements in the two pieces of legislation that seem to be a little at odds with each other, or if not totally at odds, not quite along the same timeline or flow?
Well, you're supposed to pay your property tax based on an assessment. And the Act makes reference to the assessment should be done by the 31st of March, I believe, of the year for which you're required to do the assessment. Now, I know for 2016, That was not done. And I believe there is a statement that you will be forego that, and that's the year 2017. To my mind, there may also be an issue that may arise with respect to the issue of whether the 31st of March for 2017 has already passed. So whether any assessment done now can apply to 2017 as well, and whether any assessment done now must be for 2018, to be notice of which to be served on or before the 31st of March 2018, and then you're given an opportunity. So if, for argument's sake, there's an assessment of tax with respect to 2017, then you have until the following year, I think in March, or the following year, to pay. If by March you don't pay, you have between March and September within which to pay. If September reaches and you haven't paid, then you are at 10% penalties imposed, and after that 10% penalty is imposed, there's a 15% interest that accrues on your land and building taxes. If a year passes and you have not paid, then it allows the commissioner to then treat the taxes owing as a debt, and they can now come and levy. So they could come to your home, they could break into your home, they could take chattels, fixtures, they could take your car, vehicle, hold it. They will hold it for 4 days to give you an opportunity to pay. If you have not paid, then they have the prerogative now to sell that in order to be able to settle the debt. If property tax itself still remains outstanding for 5 years, then they have the prerogative, once they go through the relevant procedure of notice and publishing and everything, advertising as the case may be, then the state has the prerogative to now forfeit your land, all right, for non-payment of taxes. Now, under Section 23 of the Act, you may also apply to the commissioner for deferral of the payment of tax on grounds of impoverishment. You just can't pay, all right? So once you're able to convince the relevant authorities of that, they then issue a certificate, the certificate of deferral. So it's not that you exempt, it's a certificate of deferral with respect to the issue of the payment of those taxes. But the sequence, 31st, you have to pay. By the September, if you don't pay, 10% penalty, 15% interest accrues from there. 1 year after becoming due, if you have not paid, the state has the right to come and levy. You take your vehicle, take goods, they hold it for at least 4 days. Within that 4 days, if you pay, everything is good. You get back your stuff. If you don't pay, then the state can then go sell your stuff in order to be able to cover the cost of the whatever taxes are owed, including the cost of the levy and and storing the stuff, all other costs associated with respect to the sale of the items. If it is outstanding for 5 years or more, then the state has the right now to forfeit your lands, right, to the state, and that's the end of your property. That's the end of it.
Is anyone exempt?
Yeah. We have churches, schools, government institutions, those exempt from paying land and building, NGOs, certain NGOs, exempt from having to pay land and building taxes.
Right, well, this is a conversation that we will continue, and